SJC-11738, Commonwealth v. Gene G. Dorvil.
Mr. Stone, good morning. You may begin.
Good morning, Your Honors. Jacob Stone for Mr. Dorvil. How may it please the court? Unless the court has any specific questions regarding whether or not to formally adopt the parental discipline defense, considering its widespread adoption among, I believe, 42 states and the constitutional and common law underpinnings, I'd like to then just move directly to...
What impact does that, if does it have on the outcome of this case? I mean, was there sufficient evidence to convict him?
There was, Your Honor, to convict him or to give the defense?
No, under the law as it was at the time, was there sufficient evidence?
Under the law at the time, I would argue that there was not. The uncontroverted evidence, I mean, the only evidence that came from the Commonwealth, from the police officers, was that they heard yelling, that they heard Mr. Dorvil say, "Shut up." There was no evidence as to what the yelling was about. They didn't say anything else that was going on. They said he was upset, and they said that he went over and he reached down and he swatted his daughter.
Well, they testified they saw that, correct?
Yes.
Was there any evidence as to there's a pat on the butt, and then there is a slap on the butt, and then there is a punch on the butt. Do we have any sense as to velocity, force?
I don't recall that there being any testimony that it was a particularly violent hit, that it was...
Was it open hand or closed hand?
I believe it was open hand, just a single spank on the behind.
Was that the word spank that was used?
Yes, that's what, I mean, they kind of alternated between spank and smack. I don't know that there's a big difference between the two when it comes to just one single spank or
But it was clear that it was just one.
Just one, clothed behind. There was no testimony about any sort of mark or injury at all. The officer said that the girl appeared frightened afterwards, but taking into account both Mr. Dorvil and Ms. Steele's testimony that the child was playing and getting close to the road, I'm sure that would be the intent of the single swat.
Was there evidence, or did any of these three officers observe to whom the shut up was directed?
No, Your Honor. They both, I believe, testified that it was just directed, I believe they said it was directed at Ms. Steele and the child.
Weren't they walking away and he was behind them? Was that the testimony? So he was yelling, "Shut up," according to the testimony, to the backs of the wife and the... Right.
He was behind them and kind of catching up.
You know, I'm a little puzzled. The appeals court, in its opinion, in its footnote, indicates that the judge concluded that no such contact occurred, that is the kicking of the child. Mm-hmm. And she relied... Did the judge make findings, or are these findings only part of the transcript, or...?
The judge, I mean, this was a...
Bench trial, right?
Bench trial. But after the conviction, in her discussions with counsel about sentencing, she said that there were discrepancies between the officer's testimonies and that he may very well have been playing with his child. So it sounds like she just found reasonable doubt in terms of the kick and whether or not he had actually, intended to go up and kick his child.
So that's I mean, there were no separate set of findings, or?
No.
Okay.
Just kind of her after comments.
And this is all on the record?
Yes, it's all in the transcript. In terms of...
So what should be our standard? I mean, I assume we have to assume the judge instructed herself with regard to it.
Correct.
And I assume, well, I assume, did not articulate what standard she was applying, or did she?
No, she didn't. In his kind of closing argument / sufficiency argument that the defense counsel made, he just said it was a reasonable force. There wasn't any kind of specific definition lended to it, at least by defense counsel. in terms of what standard the court should apply, many states have applied kind of a statutory framework that has two parts. The first part being that a parent may use reasonable and appropriate physical force, and then the second part is when it is reasonably necessary or appropriate to discipline or maintain the welfare of the child. Other jurisdictions kind of tweak that second half a little bit and argue instead that it's parents may use the force whenever the parent, him or herself, reasonably believes that it was reasonably necessary to discipline and maintain the welfare of the child. And I would argue that that second formulation is what the court should adopt in this case, following the Supreme Court's words in Troxel, where it talks about how the Due Process Clause does not allow a judge to come in and just determine that the parent made a mistake and they had a better parenting method in mind. There's a real tension there between allowing the court to balance the parent's right to control care and custody of the child versus the state's interest in the physical well-being and welfare of the child. So trying to avoid having juries and judges try to make kind of judgment standards on parenting techniques, following that second formulation.
Would you repeat that second formulation, please?
Yes, it is parents may use reasonable and appropriate physical force where the parent reasonably believes it is reasonably necessary to discipline and maintain the welfare of the child. So I think that's one particular way to.
So that's a subjective test, as opposed to where a reasonable parent. Where a reasonable parent would.
But it's a parent reasonably believes, so I take it you would get to objectively decide whether the parent was whether the belief was reasonable, correct?
Correct, yes, but it's, again, from the parent's perspective and not somebody else's perspective.
Well, isn't that what the reasonable parent would have done in the circumstances?
It's the way that these other statutes have put it together, it's whether the parent, so that particular parent. And I think the best way to kind of look at this too, and this is the second way that other jurisdictions have approached this, is to allow the court, the jury, the fact finder to really consider all of the attendant circumstances that are going on. The rules that the appeals court has kind of put forth in Rubik and that were followed in this case in the previous decision are too rigid, especially when it comes to saying that a parent must be calm when disciplining their child. I think there's a number of problems with that kind of bright line rule. First and foremost is it really just ignores the reality of parenting to a certain extent, and it could put a parent in a situation where they might be extremely upset with their child's repeated misbehavior and a correction is needed, but they would not be able to correct the child for fear of criminal prosecution. And it would, I guess, just create situations like the one that Mr. Dorvil found himself in, where he was criminally prosecuted for, in his mind, trying to prevent his daughter from, whoever you believe, whether it's the police saying he told them that she was back-talking him, or himself saying, she was being disrespectful and she was, playing too close to the street, to require some sort of cool-down period that just doesn't quite work with the realities of parenting.
Now you say the first part of it, reasonable and appropriate physical force. I know what reasonable physical force is. What's the appropriate? What's the distinction between, why would you add the distinction appropriate as a requirement?
Your Honor, I would kind of put that into the same terms as the degree of force that's used.
And why is that not? I'm concerned that appropriate arguably may mean that somebody is prepared to discuss the appropriateness of the use of force. It seems arguably to be taking away from your second point.
Your Honor, that's the formulation that has been very common in other jurisdictions, and I don't know off the top of my head why they've included appropriate. What I would suggest, though, in when talking about this kind of attendant circumstances aspect of where you should consider all of the circumstances that were going on at the time, that the degree of force should be kind of given primacy in making that determination. What Mr. Dorvil did doesn't even meet the DCF's definition of abuse. In 110 CMR 2, abuse is defined as the non-accidental commission of any act by a caretaker upon a child under 18 which causes or creates a substantial risk of physical or emotional injury. A single swat on the behind does not meet that standard. And I think it's inconsequential force, I think is the best way to kind of describe what was used. And using that kind of idea of the degree of harm done to the child or possible harm done to the child from the actions, of all of the kind of elements that could be considered, I think that one could reasonably be given primacy over the others to avoid, again, asking juries and judges to make subjective evaluations of parenting techniques. In terms of the second kind of rubric standard, whether or not the child appreciates and understands the reason for the correction, again, I think that doesn't really comport with the realities of parenting to a certain extent. A correction might be immediately needed, and the child might not understand the finer points of it, but that, again, doesn't obviate the need for the correction. I mean, that's why parents...
If the child is 3 weeks old, it may mean something.
Right, which is why it should be part of the overall considerations. I mean, it wouldn't make any sense at all for a nonverbal infant to get a smack on the behind. But a preschooler who is, according to testimony, advanced for her age, that's a totally different story. And that's why, again, not having this hard line, bright line rule makes sense. I guess just looking at all the circumstances then surrounding what had happened, Kamara, the child, she was a month and a half shy of 3, which does make her a preschooler by state definitions. There was no testimony that she wasn't a normal, healthy, happy little girl. Her parents testified that she was advanced for her age and speaking well. There wasn't any testimony by the officers that they attempted to speak with her to gauge whether or not she could understand what was going on. I know the Commonwealth talks about how her failure to understand that play had stopped is an indication that she doesn't understand correction, and I think that's a bit of a leap. Children very easily get carried away, and that's exactly the point where correction is needed. And I think at this point, Your Honor, Your Honors, unless there's any further questions, I'll rest on the brief.
Thank you.
Thank you.
Good morning, Your Honors. Audrey Anderson for the Commonwealth, if it pleases the court. Under the Lattimore standard, taking the evidence in the light most favorable to the Commonwealth, and with all credibility determinations made in the Commonwealth's favor, the question is whether any rational trier of fact could have found the elements beyond a reasonable doubt. Here the Commonwealth presented evidence that police officers on a hill, crowded street in between them from a bus station, different entrances of the police station, heard yelling and screaming. The officers left the police station and decided to see what was going on. This was even before there was a kick or before there was a slap.
But the yelling and screaming could have been, not that it's wonderful, but it could have been, have nothing to do with a child.
No, they saw, Officer Bell testified and Officer Porco testified, they saw the defendant yelling at a child and a woman. The woman was in front, the child was behind them.
Give me the order. I thought he was behind both of them.
Okay. He was. Defendant, child, mother.
Right.
Okay.
How can you tell who he's yelling at? What if he's yelling at his wife because he's upset about their disagreement about discipline on the bus?
He knew that he said that the defendant was yelling at both of them.
How could you tell? I'm sorry. From the description of what the officer observed.
Mm-hmm. From the description, if you have the child, you have the mother there, the defendant is behind them screaming, "Shut up, shut up, shut up." He is actually screaming at one of them. And it was so egregious to the officers that 4 officers went down, left the police department to see what was going on. And basically that's what they went, to see what was going on. And as they were approaching, that's when they saw the kick.
But the judge said that that didn't happen.
The judge said that there was a kick.
She said there was a kick?
She said there was a kick, and she said that maybe the defendant didn't mean to kick his child.
Wasn't that kick in connection with the other charge?
The kick was in connection with the assault and battery with a dangerous weapon.
Right, and that he was found not guilty of that.
He was found not guilty.
And the judge said, what did she say? That's because of the inconsistency in the testimony that she led her to conclude that it could have been playing around. So why does the kick still factor in?
Well, the Commonwealth gets to look at all of the evidence that happened at trial. We get to look at everything that happened at the trial court. But I'm not focusing on the kick. I was just explaining getting up to the slap.
Okay.
So after the kick, Officer Bell described it as a smack. The child then ran to her mother. She was crying and upset. Officers testified that the little girl was very upset and she seemed very frightened. The mother told Officer Bell that the defendant had been very, very mad at her and the child, and that he was upset because he felt that the 2-year-old child was disrespectful in that the mother was not disciplining her correctly.
So every time that happens, that happens a lot, doesn't it?
I was told to keep my feet on the ground, and I don't know if that happens a lot, Your Honor, that you're at...
Every time somebody gets very upset with a child for being disrespectful and then slaps him or her on the rear, that's now a crime.
According to the statute, an intentional, unjustifiable use of force, however slight.
Well, unjustifiable is the question. The question is whether a parent is justified.
Whether a parent is justified
in using force.
In Massachusetts, they're not.
I thought, isn't there even a specific jury instruction that says a parent is entitled to use reasonable force?
There's a jury instruction, but that's not law.
And it must come from somewhere. Does it come from some of our case law in which we've...
Commonwealth v. Rubeck.
Comes from Commonwealth v. Rubeck?
Commonwealth v. Rubeck, Commonwealth O'Connor.
O'Connor.
Yes, O'Connor, then there's Rubeck.
I'm sorry, so is it your view that a parent is never justified in using force, any force?
Frankly, Your Honor, in the 21st century, I don't believe that we need a law saying that a parent should be able to hit their child. I really don't think that we need that.
No, but what you're saying is that the law is the parent cannot hit the child under any circumstances. Is that what you're saying?
I'm going by the statute, and then I'm looking at O'Connor, and I'm looking at Rubeck.
Well, Rubeck says that they may use reasonable force. In a footnote, there's some discussion about the use of that may be privileged only for use of training or education. But it says that parents may use reasonable force to discipline. That's what Rubik says, right?
I think it's maybe a little, Rubik's a little departure from the reasonable standard. Rubik goes all into the age of the child, the capacity to understand. If I had to propose a law for the legislature, I would say a parent, one who assumed the full responsibility of a parent and stands in the position of a parent is justified in using reasonable force for the purposes of safeguarding or promoting a minor child's welfare. The legislator has addressed these circumstances where physical discipline can be used, can be deemed appropriate, but it has not seen fit to recognize that this authority should be given to a parent. And I'm not sure that it should be given to a parent. And the legislature has had opportunity to do this. According to the statute, was it justifiable that he smacked the 2-year-old girl and that he's yelling and screaming at her? So, I mean, this is not a little calm area. This is a huge, busy street in the city of Brockton where there is a bus station, the police station is on the hill, and there is a commuter rail behind the police station. For 4 officers, some are going home, some are coming on duty, to leave before they even see a hit or a smack, the defendant may have been out of control.
So are you saying that well, I guess let me ask you, the defendant basically proposes something along the lines of a parental discipline defense that would be reasonable and appropriate use of physical force where the parent reasonably believes it is reasonably necessary to discipline or control or correct. I'm not sure I have got this completely right, but is the idea there, are you saying that under even this standard, the defendant, there was adequate evidence to convict the defendant?
I didn't get the last part, Your Honor, if you said the last part.
I think it was to discipline or correct the child, or discipline or control the child.
And your question is?
Under that standard that's being proposed, is the evidence sufficient to convict?
Yes, because I don't believe that he was disciplining his child. The defendant never said that he was disciplining her. He said that he was playing with her. He never said discipline. Discipline came in closing arguments. It's not appropriate to, as he said, he played with his foot with the child, and then he smacked the child. No, I don't think that's appropriate or that that's reasonable. And we cannot forget the yelling and the screaming.
How did he explain the yelling to the police?
He wasn't yelling. They were playing. They were laughing and giggling. Veteran police officers know the difference between yelling and screaming and giggling and playing. But he was not disciplining her, he said. He was giggling and playing a football game, a game with his foot where he lifts her up by her hands and puts his foot on her bottom and lifts her up. Well, this time she was backwards, so he couldn't hold her hands. So he was just lifting her up with his foot backwards without holding her hands. And they were just laughing and playing. And the child was not upset at all, and she wasn't crying at all, and she was giggling.
Sorry, just to clarify. This is all coming in through the officer's testimony?
No, this is from the defendant.
Okay.
No, the officers said, both officers said, there was a kick and there was a hit. One officer was describing it as a football kick. The other officer, and they're coming from different directions, the other officer said, no, I believe there was a holdup, that it wasn't a full kick. No. So the judge said he did not convict him for the assault and battery with a dangerous weapon because she said there was conflict in the officer's testimony. But he said you did kick your child.
Are you asking us to consider the kick as part of the sufficiency of the evidence with regard to the slap?
Are you saying the judge wants you to consider that?
Yeah. The judge found him not guilty as to the ABDW.
The judge found him not guilty of that. I think the Commonwealth gets to look at all the evidence, but I'm not saying that you have to take the, I guess maybe I am saying that you have to look at the whole picture, the whole situation of what was going on.
Now, based on your understanding of the law, if a child is racing towards the street and a parent grabs her and slaps her and says, "You can't run in the street, it's way too dangerous," crime?
She shouldn't be slapping the child, but grabbing the child and get her out of the street to protect her?
Slapping the child on the rear, saying,
Oh, okay.
you should not be, you can't run in a busy city area, and because you almost ran into the street and you could have gotten yourself killed, and I'm going to slap you on the butt in order to teach you that lesson.
That's justifiable.
That's okay.
That's justifiable in protecting a child. This child was not running in the street.
Well, didn't the mother testify about that? That she was playing too close to the street, so the father said to go to the mother, and she said no, and was talking back, and he said, "I'm serious. You have to go to your mother," and she refused, so he spanked her once with his hand. I mean, wasn't it about the street issue and disobeying, not running into the street? There was testimony about that.
I think there was testimony that she was near the street, but not going too close to the street, and that was by the defendant. There was testimony of the mother and the father,
Right.
a little bit different, but there was no testimony that I read that thought that the child was going in danger of going in the street.
Too close to the street, so it wasn't in the street.
I did not, from reading the testimony, I did not get that sense that she was too close, that they were in fear of her being in the street getting hit by a car. I did not get that sense from the testimony. Are there any other questions, Your Honors?
It appears not, so thank you.
Thank
Come
you.
on with Ruff on his brief. Thank you.